Hello everyone, this is the video of Legal Studies class 12 unit 2nd and the topic that we are discussing, that is law of contract. And under law of contract, in this video we will be discussing the discharge of contract. So under this heading we have different key terms that today we will discuss. So first understand what is meaning of discharge of contract. The literal meaning of discharge is something delivery, okay, to perform certain act that is assigned. So there are different meanings of discharge depending upon the situation. So in this situation, basically in reference to contract, the discharge means performance of the obligation that is created through the contract. Okay. So let's check out what are the technical meaning of this term discharge, and before that, of course, let's check out what are the key terms that basically we will discuss in this video and the subsequent videos as well. The first one that today we will discuss, that is of course meaning of discharge of contract, and secondly we will discuss what are the modes of discharging the contract. Okay, so let's take a glimpse of all those modes and then we will discuss accordingly. By performance, that is something like universal kind of mode to discharge the contract because it is made with the purpose to perform, isn't it? So the first one is performance, the second one by agreement or consent. We will see what is the meaning of agreement or consent. The third one is impossibility of performance. Next one is by lapse of time. Next one by operation of law, and the last one is by breach of contract. So there are 6 modes of discharge of contract. So let's start with the meaning. What is the technical definition of discharge of contract? As defined, the mutual obligations created through the contract, when fulfilled, the contract comes to an end, and when the contract is ended, it is known as discharge of contract. So discharge of means termination of the mutual obligations or the contractual relations, and hence both the parties are free from each other's obligations. Well, I believe this is simple definition. You must have understood. Nevertheless, we will discuss what it is saying. See, it is saying that when through contract you created some sort of obligation, and once that obligation is completed, for example, you and your friend contracted to perform certain task, that is something like you will do certain job, that is the something like you will paint his house and in return he will pay you 100 rupees. Okay, so once you painted his house and he gives you the money, it is completed. You performed your part, your friend performed his part. So the contract is terminated because of the performance. Okay, so that is the through performance the contract terminated, means it is discharged. Okay, so in this definition, the last sentence saying that, so discharge means termination of the mutual obligations. Of course, in this example it was mutual obligations. You supposed to be paying your friend 100 rupees and your friend supposed to paint your house. So there are mutual obligations. Okay, so or the contractual relations, and hence both the parties are free from each other's obligations. Of course, once he did his part and you paid the money, both of you are free now. There is no as such obligations, isn't it? So contract is discharged. I believe you understood this concept very clearly now. Now the next point is saying that, however, apart from the performance, that is one of the modes of discharge of contract, there are 5 more possible modes to discharge the contract. Those we have seen already in the key terms, that is by agreement or consent, by impossibility of performance, by lapse of time, by operation of law, and by breach of contract. In order to understand them, let's discuss each one of them separately. Let's start with the performance. What is meaning of performance? Now I believe you must have the idea what is meaning of performance. That is doing your part, and the second part is who are also the parties of the contract, they will do their parts. So that is performance. Okay, so see what the section 37 of Indian Contract Act says. The parties to a contract must either perform or offer to perform either respective promises unless such performance is dispensed with or excused under the provisions of this act or of any other law. Promises bind the representatives of the promisors in case of the death of such promisors before performance, unless a contrary intention appears from the contract. See, I believe this definition is pretty lengthy and complex to appreciate. Nevertheless, what you need to focus on that, it is saying that as of now we understood what is meaning of performance and we are exclusively dealing with the performance. So doing your duty that is created through the contract, that is performance. Okay, but in this definition, apart from this sentence, it included all those meanings that we have discussed above regarding the modes of discharge of contract. Remember, there are 5 more modes of discharge of contract. So all those modes included in this definition that we will discuss one after another. So don't worry on that account. Okay. So first one, of course, if you are making a contract or an agreement with the intention to complete that, but nevertheless there are some unpredictability that doesn't allow to complete the performance, then there are other modes through which a contract can be discharged. So we will discuss that one after another, and that is the point that included in this definition. Okay. Now let's check out the example. A promises to deliver goods to B on a certain day on payment of ₹1000. A dies before that day. A's representatives are bound to deliver the goods to B and B is bound to pay the ₹1000 to A's representatives. Well, in order to understand this, again look back the definition that we have studied. The last sentence, what it's saying, that promises bind the representatives of the promisors in case of the death of such promisors before performance unless a contrary intention appears from the contract. Well, the same provision is defined through this example. Of course, in that contract, if there is something like representative mentioned or even not mentioned, we have studied, that is basically discussed, that is doctrine of privity. Your relative, your friends can also perform your part, and that is very well under the law. So it is same thing. If A, though he made the contract, but he dies before that day and before performing the contract on the aforesaid date, in such a condition, what will happen? his son or his any relative or his friend can also, or else whomever's name is mentioned in the contract, he or she can also perform on his part. So that is the thing, okay, and then the contract will be discharged based on the performance, okay, and that is adequately and sufficiently accepted. There is no issue on that account, okay. So that is one aspect. But the second aspect, let's check out through this second example. It is very interesting because this rule is not applicable everywhere. The second example is saying A promises to paint a picture for B by a certain day at a certain price. Fine. A dies before the day, means without painting the picture, A dies. The contract cannot be enforced either by A's representatives or by B. Well, in such a condition, this is so technical aspect that the kind of work that is involved in this contract, that is done by only A, because it is technical skill, okay. In that condition, it cannot be performed, and no one can, even there is some representative mentioned in the contract, even he or she cannot be forced, because it is not the kind of job representative can do. Nevertheless, there is situation something like that. Suppose there is a company or a team, even son or father, even father promised something, both are doing the same business, both are an artist. So if father committed someone or made the contract, he will be making a sculpture of B, okay. Then in the middle of the work he dies. In this condition, if his son is skillful enough to complete that work, then his son is obliged to complete that work, okay, because that is possible to do. So it depends upon the situation, okay, in which it is contracted, okay. So there are certain aspects that you need to focus on while discussing the contract. If you miss one point, you will miss the important point, okay, and you won't able to appreciate the concept. So there are exceptions, there are solutions, so everything is there.